If you ask anyone in the society today, what's the latest and the hot topic, no one will say that he or she doesn't know. Yes, it's obvious. It's the impeachment. And today, we at the national television are going to bring you kind of a comprehensive interview on this topic, impeachment. And we have with us attorney at law, Mr. Gomin Dayasri. Welcome, Mr. Dayasri.
Thank you for inviting.
First, would like to know, on the heels of this determination of the Supreme Court, what's the next process of the impeachment saga?
Well, presently, I suppose it would have to go before the House and there would be a debate and it will conclude with a vote being taken. And if there are more than half the number of MPs who are present in House...
They need a simple majority.
No, it's a special majority. It's not a simple majority. That is something unique in this. And if they get that majority, then it goes before the President, who has a discretion to rethink over the matter and then make a determination whether the removal should be effected or otherwise.
Right, okay. But with the latest determination of the Supreme Court, it says that the Standing Order 78A is not in line with the Constitution. How do you respond to this kind of a situation?
Well, I do not think the majority in Parliament will accept it, and it will be the majority decision that will matter. So I think it has been quite clearly laid down that the Parliament will not bow down to the judiciary. I mean, that should not be so, because I do not think in any sense that the people's representatives should be in a way curtailed or restricted by a judiciary, in the sense the judiciary has the right to interpret. But if they go beyond interpretation and try to stop the functioning of the Parliament, then I think they may be acting in excess of their powers, and certainly, whether they are or not, the Parliament will not succumb to that. And if they do so, that will set a very dangerous trend where the judiciary may try to overwhelm the Parliament in the future.
But don't you think that the sole and the exclusive jurisdiction of, especially to interpret the Constitution, lies with the Supreme Court? So in that scenario, coming out with this kind of determination, don't you think that's kind of a fair situation?
No, because is it merely a determination where interpretation is the prime purpose? Interpretation would mean you are giving a meaning to a certain situation. But to say that the whole concept revolves around 17A. 17A says that whatever rules that are to be made should be made either by law or by standing orders. Now this court, the decision of the court considers only the law. They don't give attention to standing orders, which is the alternate. And if you look at it, they are on par. So that the Parliament normally regulates their internal affairs through standing orders, and that has been a practice from the time of the first Parliament, and it has never been challenged. So that I think if you read that section, especially since there's a section on what the written law is, and the written law is clearly, it comes under the definition of a standing order comes under it. So I do not know whether the decision in that sense, the interpretation is quite accurate. Because you see, today no longer is the view held that decisions of court can be kept in bottles of cotton wool. With the right of expression, people have the right to criticize, provided they don't do it with the intention of bringing disrespect to court. It is always a useful thing for criticism, because the current thinking is, with the freedom of expression, you can make criticisms of any order, provided it is not in any way manner degrades the judicial structure. So my own view is that there are many infirmities in the judgment, and certainly I am very certain that the Parliament will now not bow down to it, because the Speaker probably may make a pronouncement on it.
So who decides on the ambit of the term, the power of the Parliament then?
Power of the Parliament is determined by the Constitution, and that is a matter that the Constitution has laid down certain procedures. Now take the procedure in 78. Now we have had this for 25 years. There have been so many impeachments We had the impeachment of Neville Samarakon, we had the impeachment of Percy Colling-Tommy, we had the impeachment of Vimalaratne. Now, though there may have been criticisms at the time the impeachment proceedings were going on, what happens unfortunately in these countries, after that people forget about it. And it's very sad and tragic, because if you look at it, the judiciary, especially the judges of the Court of Appeal, the judges of the Supreme Court, are a very powerful lobbying factor. But what has happened is, though they have had this unfortunate episode of having to deal with this kind of impeachment and with these rules which they say are unfavorable, after the event they fall asleep. They don't wake. I mean, everybody, whether these people who talk about civil rights or people who talk about human rights or proper procedures, including the judiciary, they just sleep over it till another thing comes. I mean, we have had 25 years of it, and if that is bad, why was it not changed? Now look at the media. They were very hostile to criminal defamation. They agitated, they protested, and media is not as strong as the judiciary. But still, end result is they got it off the penal code. So,
but now we see the the person who is holding a high post like the Chief Justice in Sri Lanka and going around filing cases against the members of the parliament, against the parliament and the speaker. And how do you see this kind of situation, especially when she has to deal with all these issues pertaining to the government as well?
I think it's tragic. I think it's unique. It's something that should have been avoided at all costs, because today what we see is a major conflict between the executive and the judiciary, the legislature and the judiciary, and really it centers around one person, the Chief Justice. But the Chief Justice has blown this situation, bringing in lawyers, addressing the judges. It has really got, in proportion it has grown. But all that is beside, because let us say she has the right to make her representations. I mean, she wants her point of view expressed. Oh, all right, justifiable. But there's something which really troubles me a lot. That is, she is in conflict with the executive and the legislature. She files action. She files action which is against the state, against the parliament, against the speaker, against members of the House of the Parliament. Now, majority of the cases, maybe I would say 70% of the cases she deals with, is where the government is a party. Often the party against whom action is filed. Now, can she, as a judge, hereinafter function when she herself has gone to court, when she has quarreled with the legislature and the executive? What would be how would the public, the reasonable man look at it? They will think that she is partisan, she is biased, she is prejudiced, because never in the history of litigation have I heard of Chief Justice taking the state or fighting with the legislature and the executive. Now we have seen these things happen many times, like when Neville Samarakon was the Chief Justice. He had a similar impeachment, but it was a very private matter. I mean, media did not get involved in it, the lawyers did not get involved. Why? Because Neville Samarakon was very concerned that this is a dispute concerning him, and he dealt with it with his lawyers. I mean, there was no question of coming out where you were cheered, and when you go further down you're jeered. No, I think being either cheered or jeered is both bad things. We must not allow either to take place. But you see, the question is, can such a person hereinafter function as a moderate, unprejudiced, unbiased person when you are fighting with those very organized? In the minds of the public, in the minds of the reasonable man, they will think, is she fit now to be a judge in a cause where she herself is fighting the same party?
So do you figure out some kind of a hidden agenda behind her behavior, or like kind of a different assignment on this kind of a situation?
I don't think she herself would be having an agenda except her own agenda of preserving the office. Mm-hmm. But behind her, I think what has happened is a large number of other forces have joined with personal agendas, with agendas which have a political flavor, agendas that have anti-Sri Lankan outlooks. So there are today, if you look, most of them, I won't say everyone, there are certain lawyers who are doing it because of their beliefs, but a large number have joined ranks with her who were very prominent characters even during the war, in the anti-war campaign. So there may be, I feel, certain elements who want to bring disrepute to Sri Lanka, because undoubtedly this is bringing disrepute to Sri Lanka as far as the international image is concerned, as far as our presence in Geneva in March is concerned on human rights. So I think there are groups of persons, if you look at the lineup, who have joined hands with her, who are propelling this issue as a measure to propagate their own views on various issues, their agendas. So I think she has been a victim, unfortunately, of that kind of thing, which is not bringing her great repute, because it would have been much better if she, as an individual, as the Chief Justice, fought it on her own without bringing other forces, because now who is the ultimate loser? It's the country. I mean, it's a country. I mean, we are looking up and spitting at our own selves, and who is doing this? The main characters, whether it is the President or the Chief Justice or the Speaker or the Parliament. I mean, the main characters are involved in this, whereas it should have been as it happened previously. Now, let's take the case of Justice Vimalaratnam. He had an inquiry. At the end of the inquiry, he was exonerated except a warning, and he came back to the bench and practiced. No one knew what had happened. I mean, that is how it should be. The dignity of it must be maintained. That is why I say once again that either jeering, cheering is not good, and those are all done by organized groups. So I think it would have been much better if the Chief Justice dissociated herself, because when you get amalgamate yourself in thought and action with the legal profession, there could always be criticisms that there is favored treatment when cases come up. I mean, that is because you see, in law, what is material is not bias, but likelihood of bias. When there is an appearance that there is some element of bias or possible bias, then that person is disqualified from hearing. I mean, he may be totally unbiased, but the appearance of bias is very important. So here, this kind of close association, because now Neville Samarkand totally dissociated. He took the best lawyer to defend himself, but he didn't get lawyers to organize various tamashas, shows, road shows, and then what happens is the other side even does it worse. So in the end, what happens? It is the judiciary that loses, not so much the system of law, the legal systems of this country is brought into disrepute. The country is brought into disrepute. So that is not good. So I think responsible people, whether it is the President or the Chief Justice, they must think of the country. They must act like responsible people, maintained in the dignity of office.
Right. Okay. Coming back to this, the entire impeachment process, Mr. Dayasri, I would like to know now this. The Supreme Court, in its determination, mentioned that the Parliamentary Select Committee, which was appointed to probe about these allegations, it's not constitutional. Especially, it was appointed through a standing order, not by law, and finding a judge guilty is not constitutional. How do you respond to this?
Well, I think that is going beyond interpretation. That is, I do not think that falls into the realm of interpretation, because you are making pronouncements on a sprawling issues. Now, leave it as it is, but will the Parliament succumb to that? Will the Parliament accept the rulings of court which are trying to curtail, restrict their affairs? I don't think they will do, and that is something one should be aware of, because if you remember, the same thing happened when Sarath Silva was the Chief Justice, and Honorable Bandara gave a declaration, and what did Sarath Silva do? He didn't become confrontational. Now everything is confrontational. So that here are parties who have to work together. If a country is to progress, the judiciary, the executive and the legislature must work hand in hand. They must maintain a distance, but certainly judiciary has to have some nexus. But the problem is now in this kind of hostile climate, I mean, it's very difficult for a country to progress, and this is the very reason that the leaders don't understand.
No, my question was actually, can a parliamentary select committee find a judge guilty?
Well, Parliament certainly they can, because it has happened before. There are rules for that, and this kind of technicalities, I don't know the validity of those arguments that have been submitted. So that I feel that Parliament should never encroach into the affairs of the judiciary, and just as much as that, the judiciary should not encroach into the areas of the legislature. But what is happening is the reverse. They are penetrating into the others' areas, and there is a conflict situation.
You mean to say even the Parliament Select Committee went beyond their mandate?
Well, I would say Parliament Select Committee has many deficiencies. I mean, it went like an express train. I mean, they should also have given them more time. But I think there was a bigger mistake made there. I think the Chief Justice should never have deserted, left the proceedings, because she is the ultimate loser. Because when a person drops out of a case while it's proceeding, then you have what is called ex parte hearings. That is only one side is heard. Now that is exactly what happened, so that the opposing side to the Chief Justice was able to splash everything on record. Yeah. Now you see, these are matters that will be examined in several years ahead by historians, sociologists, and the interpretation they will give may be unfavorable, because in some of these things maybe the Chief Justice had responses, valuable responses, but they were not ever ventilated. The important thing is when the accused judge must lay her or his trumps on the table. He must show that these are the reasons why I should be exonerated.
And she asked for 5 weeks.
She asked for 5 weeks, but I mean, I have asked for cases not 5 days, 1 day. Sometimes you don't give. You are not given, because even if you get a limited period, as lawyers we know techniques of how to get around that situation and get time.
Manipulate? Not
manipulate, I would say strategic planning.
Approach. All right, okay.
In other words, you can tell, which is often with I do. Well, I'm asked straight away to start a case. I tell them, okay, I will start the case, no problem. You put your first witness, and I cross-examine. And at a certain stage, when I need instructions or documents, I ask them to adjourn that and bring another witness, so that the witnesses are paraded. But at the same time, we reserve the right of cross-examination at the time we are more better equipped to do so.
So you mean to say that not giving kind of a time period to her for her to respond back is kind of a fair one?
I would say that she has. I would say that she has been given time, but even there may be even accusations of not being given time. But the main thing is you must be able to adapt yourself to the situation, not run away. Because when you run away, you lose much more, because you can't get your viewpoint across at all. So I think strategically she made a major error in keeping away from the tribunal, because she should have been there defending herself. Because later on, I mean, at any day, if there's a revisit, all that is on record which is favorable to her.
Right, okay. So you're watching an exclusive interview here on the national television, especially on this, the hottest topic in the town, impeachment. We have with us Attorney at Law, Mr. Gomin Dayasri, talking to us on this entire process. Mr. Dayasri, next would like to know now, don't you think that at a PSC hearing, the Parliament Select Committee hearing, giving someone a fair hearing is kind of the need of the hour?
Undoubtedly. Undoubtedly you need but may I also say, though you say it is the hottest topic, Vas, it is the hottest topic undoubtedly between the Kalaniya Bridge and the Moratua Bridge.
Okay.
But I do not think the people in this country, when they live in Tangola, Anuradhapura, or Badulla or Monaragala, they are so interested in it, because the most recent survey I saw, strange, but only 17 people even know what they say in Sinhala is Dosha Bimo Yog is. So that this is not the issue. The issue that touches people are things like economic issues. These are issues that is attractive to the intelligentsia, the opinion makers, the lawyers, the media. But it's not an issue that has penetrated the people. People are still unaware of it, and they hardly care for it. They no concern. It's more an academic issue. It's an issue for the elite.
Even the Bar Association of England and Wales have expressed their concerns over this issue recently. And how do you see this kind of situation, especially what kind of an image will this transpire, especially to the international community?
The image will be very corrosive. Image will be very unsatisfactory as far as Sri Lanka is concerned, because undoubtedly this is another opportunity for those who are trying to bring us on human rights violations to say, hold out, there's no proper law and order. So I think we are gifting a prize to our opponents by this kind of conduct. And that is why I keep saying that the responsible people must act with responsibility. That's very important, because as it is, I find that even the Chief Justice is only interested in her cause. I mean, very justifiable, you are more interested in your cause than anybody else's. But at the same time, you must think of national interest. If you can't get on with some people, if you are in a confrontational situation without being combative, you should try to reason out and probably move in a different direction, which I suppose is always possible, but now it may be too late.
So what's the way forward for the Chief Justice?
Well,
now?
I think in the first instance what she should have done is she should have initiated talks with along with the leader of the opposition, meet the president, and hold talks as to what has gone wrong, and then try to rectify it. But here, on the contrary, it has been from the beginning very confrontational. People going to courts, filing action, so that it's very difficult for the two parties to get too close to each other because of their own conduct after the impeachment motion was put into operation.
So don't you think that the government is the authority who appointed Dr. Shirani Bandaranaike as the Chief Justice, and knowing that her husband is head of bank institution in Sri Lanka, state bank institution in Sri Lanka, don't you think that the government made a mistake in this scenario?
No, I don't think the government made a mistake, because I think what happened was she was offered the post, and when she accepted it as the senior most judge, I think there was an attempt to find some kind of valuable employment for the husband also. So I think really that is the cause of this problem. I think the president was very wrong in giving appointment to a spouse of a judge, because it can always be construed as a desire to get some kind of reward or benefit. So to that extent it's bad, but at the same time, or equal worse, is the Chief Justice accepting it. I mean, you must know what should be accepted and what should not be accepted, so that if the people get the impression that the Chief Justice has done this with the intention of some kind of financial benefit or any other kind of benefit, even if it's a wrong notion, that is not good for the judiciary. That is not good for the judiciary, because the judiciary is always expected to be above everybody. That is why, in the old days they used to say Nadukara Hamuduro, and that image should stand, because they, unlike politicians, are able to extract respect. So I think they are a group that must be preserved. But when they go and conduct themselves in a manner that is unorthodox, undoubtedly you run into all kinds of complications.
Okay, one final question to Mr. Dayasri. Now, if the government, most probably towards the end of this week, we will, get a final verdict out of this entire the impeachment saga. But if the government goes against this determination of the Supreme Court, will the country fall into an anarchy?
No, I don't. You see, this is not an issue that has reached the people for them to get agitated. If there are any street shows, those are all organized. Those are staged. I don't think this is an issue. If you tell me that economy may be an issue, I am more likely to agree, because this is neither a sentimental issue nor, you see, people like a film star, a politician are attractive people to the public. As Chief Justice is an unknown element. I mean, to the average man in Sri Lanka living in the back beyond,
to the majority
of the people, it is not an issue. I mean, this is just they see it in newsprint. But I don't know if the survey show only 17 are even aware of what it is. I think the people who know must be probably in a single digit. So no, I don't think this will create, but it will have great international ramifications, which might be very dangerous. And also, I think there is an attempt to make political issue out of this to gain political mileage. And at the same time, I think the government also has not acted in a sensible way, because I think they could have curtailed this situation, and the Chief Justice equally has been acting more in her own interest and gathering forces, no doubt beneficial to her. But I think in these matters you have to look at a larger interest, because these are responsible people. They have to think of the country first. That is just not happening.
Not the micro elements, but the macro elements.
No, it is not the selfish elements. You have to think of what is good for the country, because you're not Vas or Dayasri. You are the Chief Justice and the President. So that means that you are carrying a very heavy weightage. So you can't act to improve, enhance your personal fortunes. It's a large issue.
Thank you very much, Mr. Gomin Dayasri, the attorney at law. And today, in fact, we discuss about this the impeachment saga, which has been revealing kind of the hot topics in the town. And hope you enjoyed. And once again, would like to express our extreme gratitude to attorney at law, Mr. Gomin Dayasri. Thank you very much, and see you once again with this kind of an interview. Till then, have a wonderful time.
He's standing on this Sinhala.